I want to talk about this Mebounds trademark, and I think you could benefit from an analysis from somebody who knows trademark law and understands the league as well. As a very brief background, Angel Reese of the Chicago Sky leads the league since she's been in the league in rebounds and is particularly good at offensive rebounds, which ordinarily would be considered a great thing, but she has her critics who have coined the term Mebounds as a means to criticize her because she sometimes misses shots and then gets her own board. She has decided to take this in stride, and she announced that she's going to apply to register a trademark in Mebounds and merchandise the Mebounds trademark with her own company. And you can see some of the t-shirts that are here. And true to form, there is an application to register the word Mebounds with the United States Patent and Trademark Office. So a few points. Number one, this is an application to register a trademark, not a copyright, not a patent. Trademark, copyright, and patent are all intellectual property, but they are very different things and very different functions, and we do not conflate those terms. If we're watching a game, Sabrina nails a three, and I go home run, you would know not to trust my analysis of basketball or sports in general, and that's what people sound like when they mix up trademark, copyright, and patent. Number two, I'm not always a big advocate of rushing to the trademark office just because you've become well-known or associated with a phrase or term. It's often just not necessary if you don't have a plan associated with it. But that's something to think about on a case-by-case basis. It seems like Reese really does have a plan, and she's nailing it with this merchandise. Number three, this is not a registered trademark. This is not, what you see here is not evidence of a registered trademark. The application was just filed a few days ago. What we're experiencing now with the United States Patent and Trademark Office is if everything goes smoothly, the process to registration takes about a year. Now, that doesn't mean you don't have the right to use it during that time. Of course she's going to, and typically you're going to when that merchandise has become available, but it is not a registered trademark. It is an application to register a trademark. Number four, the application was on an intent to use basis. That means you're telling the trademark office that I intend to use the trademark for these goods at a later time. And since then, the merchandise has become available. And this is very common where you first apply on an intent to use basis to establish your priority against any other jokers that might come later. And soon after that, you make your merchandise available because typically you want to make it available to the world when it is ready. And when you do that, you often will file an amendment to allege the use, and doing it that way makes it a use-based, essentially, application, which can speed up the process. But again, it's not likely to take less than 12 months, not these days. Number five, what obstacles are there going to be to registration? I can't address all the potential ones. I just want to talk about one because it's very common with t-shirts and other clothing, which is ornamental use. That means, as far as trademark law is concerned, that when consumers see a clever phrase on a shirt, they think, haha, that's a clever phrase on a shirt. They don't associate it with one source, with one company, the way they do a swoosh. And trademark examiners tend to be inconsistent with this type of refusal, much like WNBA refs. For instance, years ago, Lizzo became famous for 100% That Bitch and applied to register the trademark in numerous classes and did fine except for the t-shirts. Got a refusal for this t-shirt on the basis that this was an ornamental use, not a trademark use. By contrast, way back when Nike became known for Just Do It, they applied to register the trademark in Just Do It. This was the shirt that they used for their specimen. Look at the two side by side, and that was approved. They did not get any initial office action refusing, to my recollection, that registration. Now, you can draw your own conclusions of why there's this inconsistency, but I'll tell you this much. Around the time that Lizzo was applying, there was this loose-knit group that called themselves Trademark Watchdogs. And what they did was they found what they decided was abusive uses of the trademark system and filed letters of protest with the United States Patent and Trademark Office. The letter of protest is a less used mechanism. It is less formal than an opposition. It doesn't raise any proceeding. It is just basically snitching. It is you're filing something with the Trademark Office that an examiner can choose to address or ignore, letting them know what you think are any potential obstacles to that registration. I don't know if that's what affected the Lizzo application, but that group was pretty active at the time. Don't know where they are now. I think based on this that the association between Mebounds and Angel Reese is kind of strong. She's making it stronger. Her fans are making it stronger. Her critics are making it stronger. So I do wish her success in this. Not so much When the Sky Comes to Valhalla. That's a complete other story. My name is Mark Jaffe, Five Bridges Law, representing creatives in California and New York. Go Valks.